believability. Credible witness is a witness whose testimony you believe. In considering the testimony of any witness, you may take into account his or her ability and opportunity to observe what he or she has testified about, the manner and conduct of the witness while testifying, any interest, bias, or prejudice the witness may have, any relationship the witness may have with other witnesses or interested parties, and the reasonableness of the witness's testimony considered in light of all the evidence you have heard. Assuming that each witness has testified truthfully, if you find conflicts in the evidence, reconcile those conflicts if you can, based on the assumption that each witness has testified truthfully. Do not disregard the testimony of any witness without a reason and without careful consideration. If you find conflicting testimony that you cannot reconcile, decide what testimony you believe and what testimony you disbelieve. In deciding what or whom you believe, you should use your own knowledge, experience, and common sense gained from day-to-day living. If you decide the plaintiff is entitled to recover damages, you must separately decide the amount owed to that plaintiff and list that amount on the verdict form. If you decide from the greater weight of evidence that SVT is liable to Clyde Franklin, then you must decide the amount of money that will fairly compensate him. In deciding the amount of money awarded, you may consider 1. the nature and extent of the injuries and the effect of the injuries on his ability to function as a whole person, whether the injuries are temporary or permanent, the physical pain and mental suffering plaintiff has experienced and will experience in the future as a result of the injuries, the reasonable value of necessary medical care, treatment, and services plaintiff incurred and will incur in the future as a result of the injuries, and 5, the life expectancy of the plaintiff. Plaintiff Clyde Franklin asked you to award money based on his impairment because of her injuries and her life expectancy. According to standard mortality table, life expectancy for a male person 67 years of age is 15.8 years. This is evidence you may consider in determining the amount of money you award, if any. Mortality tables are merely estimates of life expectancy. They are based on statistical averages of the remaining length of life of all persons in our country of a given age and sex. Considering life expectancy plaintiff, you may evaluate all facts and circumstances that bear on his life expectancy of plaintiff, including the mortality tables of his occupation, health history, state of health, and habits. An employer is liable for the negligence acts of its employees done within the scope of their employment. An invitee like Clyde Frank is a person who a property owner, SVT, LLC, invites to enter or remain on its property. Reasonable care means being careful and using good judgment and common sense. This case must be considered and decided by you as an action between equals under the law. Individuals and groups of people, such as business or governmental entity, stand before the court and before a jury with equal rights and with equal obligations. They are entitled to the same fair and are to be given equal justice. Therefore, you should not allow sympathy or prejudice for or against any party to influence you or control your verdict in any way. Your verdict must be based on the evidence and on the instructions of the court. You must not consider testimony or exhibits that are not admitted into evidence. Generally, a witness may not express an opinion. However, one who follows a profession or special line of work, as Dr. Shakiri in this case, may express an opinion because of his knowledge, skill, experience, training, or education. Judge opinion testimony in the same manner that you judge other testimony. Deciding how much weight to give testimony, you may also take into consideration the witness's skill, experience, knowledge, and familiarity with the facts of the case, the reliability of the information supporting the witness's opinions. 3, the reasons for the opinions. Consider all of my preliminary and final instructions together. Do not single out any individual sentence, point, or instruction and ignore the others. A party may present testimony by way of written or video deposition. A deposition is a sworn testimony of a witness taken before trial. The witness is placed under oath and swears to tell the truth, and the lawyer for each party may ask questions. A court reporter is present and records the questions and answers in the case the deposition was placed in their evidence. Evaluate this testimony using the same rules you apply to the testimony of other witnesses. A party may attack the credibility of a witness by showing that the witness made a statement or behaved in a manner inconsistent with the witness's testimony. You may consider the fact that a witness spoke or acted inconsistently with his testimony in this case only to determine the weight you will give to that witness's testimony given during trial. However, if a witness has testified inconsistently under oath, you may also consider the content of the witness' prior inconsistent statement as evidence in the case. Base your decision on the evidence and not on guess or speculation. However, damages need not be proven to a mathematical certainty. Plaintiff Clyde Franklin's fault, if any, is an issue in this case. If the plaintiff's fault was responsible cause for his injuries, then the plaintiff either will receive no compensation or will receive only partial compensation for the injuries. Another instruction will tell you how to determine the effect of plaintiff's fault, if any, upon your verdict. The defendant, SVT, LLC, has the burden of proving by a greater weight of the evidence that the plaintiff was at fault. SVT claims that plaintiff Clyde Franklin's own fault contributed to the injury plaintiff claims to have suffered, and that the plaintiff's fault was the responsible cause of the injury. SVT, LLC has the burden of proving by a greater weight of the evidence that plaintiff was at fault. In this case, there are two issues, liability and damages. The fact that the court has instructed you regarding damages does not mean that the court necessarily believes that the plaintiff is entitled to damages. In addition, the fact that a lawyer for a party has been sued, has discussed the subject of damages is not an admission by them that any party who has been sued was at fault, or that any damages to the plaintiff was caused by any of the parties who have been sued. These instructions regarding damages have been given to you because the subject of damages is an issue in this case. The instructions regarding damages should be considered by you only if you determine under the instructions of the court and by the preponderance of all the evidence that the plaintiff should be awarded damages from any party that has been sued. You are further instructed that even should you find for the plaintiff on the issue of liability, you are still not permitted to compensate him for speculative damages. By speculative damages, I mean damages for injuries which, although possible, are nevertheless remote or based on conjecture. If you should find that the defendant is liable to the plaintiff is entitled to recover only such damages as he has proven by a fair preponderance of all the evidence to have directly and proximately resulted from the occurrence in question and not otherwise. Clyde Franklin was an invitee on the property of SVT LLC. An owner of property is liable for injury caused by the invitee by the property's condition only if SVT LLC 1. knew that the dangerous condition existed and realized that it created an unreasonable danger to an invitee, or should have discovered the condition and its danger. Should have expected that the invitee would not discover or realize the danger of the condition, or would fail to protect himself or herself against it, and fail to use reasonable care to protect the invitee against the danger. A person's conduct is legally responsible for causing an injury if, 1, the injury would not have occurred without the conduct, and 2, the injury was a natural, probable, and foreseeable result of the conduct. This is called responsible cause. There can be more than one responsible cause for an injury. The finding of negligence may not be based on mere surmise, conjecture, guess, speculation, or probability. When you return to the jury room, you select one of your members as presiding jurors and manage all deliberations. No one will be allowed to hear your discussion, and no recording will be made of what you say. The bailiff is available to assist you with personal needs, but cannot answer any questions about the case. If you have any questions for me, you must put them in writing and give them to the bailiff, and I will respond as the law permits. You may be able to find answers to your very questions by reviewing my written instructions and all the evidence. If at any time you are not altogether, or if you are outside the jury room, you must not talk about the case among yourselves or with anyone else. I am giving you forms for possible verdicts. The presiding juror must sign and date the verdicts to which you all agree. Do not sign any verdicts forms which there is not unanimous agreement. Then you will hand them to the bailiff. The bailiff will bring them with you back in court. You will bring all verdict forms, signed, unsigned, with you at that time. I will read the verdict aloud. Each of you may be asked if it is your verdict. Otherwise, you are under no further obligation to discuss your verdict or deliberations with anyone. In writing your verdict, you must not consider the tax consequences of any of the money you may award. To recover damages from defendant SVT LLC, plaintiff Clyde Franklin must prove each of the following by a greater weight of the evidence. SVT was the owner of the property. Plaintiff was an invitee on the property owned by SVT LLC. Plaintiff was injured as a result of the condition on the property, and SVT LLC knew that the condition existed and realized that it created an unreasonable danger to invitees, or should have discovered the condition and its danger. Should have expected that the invitee would not discover or realize the danger or condition, or would fail to protect themselves against it, and fail to use reasonable care to protect the invitees against the danger. To decide if plaintiff Clyde Franklin is entitled to recover damages from defendant LLC, DBA Strike and Van Tills, and if so, the amount those damages apportion the fault of the plaintiff. Clyde Franklin and defendant SVT DBA Strike Van Till on a percentage basis do as follows. First, if defendant SVT is not at fault, return your verdict for defendant SVT and against plaintiff Clyde Franklin and deliberate no further. Use verdict form A. Defendant SVT is at fault. Decide defendant's percentage of fault and a percentage of fault, if any, of plaintiff Clyde Franklin that caused the plaintiff's injuries. These percentages must total 100%. Do not apportion any fault to any other person or entity. Next, if plaintiff Clyde Franklin's fault is greater than 50%, return your verdict for defendant SVT and against plaintiff Clyde Franklin in this case, and deliberate no further. Use verdict form B. However, if you decide that plaintiff Clyde Franklin's fault is 50% or less, decide the total amount of plaintiff's Clyde Franklin's damages, if any. Do not consider any fault when you decide this amount. Multiply plaintiff Clyde Franklin's total damages by defendant SVT's percentage of fault. Return your verdict for plaintiff Clyde Franklin against defendant SVT in the amount of the product of the multiplication. Use verdict form C. I will give you verdict forms that will help you guide you through this process. All right, now you can pass that one out. Okay. Plaintiff Clyde Franklin filed an action against the defendant SVT LLC DBA Strack and Van Tills. Hereinafter Stracks. The basis of the lawsuit is negligence, alleging the Strack failed to properly maintain his grocery store in a reasonably safe condition, failed to exercise reasonable care in the maintenance of his premises, and had notice, or should have had notice, and failed to reasonably cure or respond to a defective condition on the property. As a result, Clyde Franklin fell and is claiming the following medical care, pain and suffering and permanent injury. The plaintiff has the burden of proving these claims by a preponderance of the evidence. Strax denies that it negligently maintained its store and that it had notice of a defective condition on its property, and denies anything they did proximately cause plaintiff's injuries. Strack has no burden to disprove these claims of the plaintiff, as I already stated, and it is the plaintiff who has the burden to prove these claims. However, Strack has claimed certain defenses and has the burden of proving those defenses by a preponderance of the evidence. These defenses are the plaintiff was at fault and incurred the risk of his injuries. Strack further contends the nature and extent of the injuries and damage complained by the plaintiff. Contest the nature and extent of the injuries complained by the plaintiff. Juror number 104, you have been selected as the alternate juror. Your duties are the same as those of a regular juror, except you must not participate in the deliberations or voting of the jury unless I direct you to do so. The presiding juror of the jury shall prevent alternate jurors from deliberating or voting with the jury. The presiding juror shall promptly report any violations of instruction to me. All right. Members of the jury, in a moment you are going to retire and deliberate your verdict. After you retire to the jury room, your first act is to choose from among you persons as a person as a foreperson, the presiding juror. The court is prepared and now submits to you forms of verdict to meet all the phases of the case that you must use. After your deliberations and when you have reached your verdict, the proper verdict form is prepared, signed by the foreperson. You'll bring it back out with you. Then we have, I don't know if you've seen it on the wall back there, I think there's instructions for you in choosing your presiding juror and how you should conduct your deliberations. I would, where's my bailiffs? Step up here. Mr. Ron Williams and Alex Serafin, do you solemnly swear that you will take the jury to a convenient place for deliberations, that you will not communicate with them yourself with regard to this case, or allow anyone to do so? Ask them if they have agreed on a verdict, and they having done so, you will return them to open court, so help you God. All right, you may now escort the jury to the jury room.